Good morning, everyone. My name is Guido Notoladiag, and I'm an associate professor of intellectual property and in privacy law at the University of Stirling. Today, I would like to present some work in progress that is part of a book I've been working on now for some time about called The Internet of Things and the Law that is hopefully going to be published by Routledge this year. In particular, I'm going to focus on one aspect of the relationship between intellectual property and the Internet of Things. And this is the what some scholars like Joshua Fairfield called the death of ownership. So I'm going to present this concept and then I'm going to reflect on one possible solution to the problem and draw some conclusions. Now, sort of the start of my interest for this concept of death of ownership dates back to Joshua Fairfield's book, Owned, that you can see hopefully on this slide, where essentially he puts forward the idea that in the current state of technology, in particular with the Internet of Things, we are no longer owners of our property or of our smart objects. Rather, we are digital tenants, digital peasants in a way, like in feudal times where people wouldn't own property, they could only manage property on behalf of the lord. Now with the IoT companies are the digital lords and we are the digital peasants. And this is because of kind of two possible factors. One is that IoT companies reserve ownership over our devices formally. And this can happen, for instance, if you are leasing an object, perhaps, and so you're going to commit to give back that object at the end of its life cycle for instance, green sort of sustainability reasons. But more importantly, I think the death of ownership is related to another type of scenario, the scenario where in theory you own your smart objects, but actually you don't have any control over it for reasons that are factual, legal, and technical as well. When I say legal, in particular, I'm going to look at contractual and intellectual property issues. And the other thing that I would like you to sort of keep in mind when reflecting on how the death of ownership plays out in the context of the IoT is that smart devices are not just hardware, software, service, data, and digital content. They are an inextricable mixture of hardware, software, digital content, service, and data. And if we don't have control over even just one of these components of our devices, then we don't really own them. And to sort of just do an example briefly on of what I mean by factual control, and this factual control often plays out in the context of control over data and control over services. As an example, I submitted subject access requests under the GDPR to Amazon because I own Amazon Echo, a couple of Amazon Echoes, and I simply wanted to know which kind of data they were sort of processing and they were storing about me. And I was a little bit disappointed when they replied to my subject access requests with hundreds, if not thousands, of tables like the one that you can see on this slide. A table that really doesn't mean much to me, if anything at all, and doesn't really give me that kind of interesting and important information that I would like to have about what data Alexa is using about me, the data about my profiles, the data about the inferences that Alexa makes about my preferences and about my behavior. The use that Alexa makes of my emotions, because we know that Amazon patented an invention that essentially analyzes our feelings and emotions based on our voice, and monetizes on that. But there is no trace of that. And this is, I think, just an example of a type of factual control. And related to this is also the fact that in theory, you can delete the recordings. So as a default, Alexa is storing all the voice interactions that you had with her, or with it, I should say. In theory, you could delete these recordings. However, if you delete these recordings, Amazon is telling you that this is going to affect the functionalities of your device, and therefore you don't really have an incentive to actually protect your privacy and gain control over your data. Legal control, as I said, it's contractual control, but also IP control. When it comes to contractual control, if you buy a device that is as simple as a speaker or as a thermostat, you would never expect to be sort of submerged by hundreds of terms and conditions, privacy policies, community guidelines, and user license agreement, etc. In particular, in the scenario of Amazon Echo, I counted personally 254 contracts that you are accepting when using Echo. And it's not just a matter of sort of quantity, it's also a matter of quality. IoT companies really use contracts as a weapon to gain control over your device, and ultimately, one could argue, over you. And this can be seen, for instance, in these quite interesting terms that I found analyzing this use case. For instance, under Amazon Prime Video terms of use, you have that purchased digital content may become unavailable, and Amazon will not be liable to you. So in theory, you own the digital content in your Amazon Echo. However, if it becomes unavailable, nobody will be liable for it. So which kind of property is it if anybody can steal it from you without any form of liability? Related to that, there is this term in the additional software, Amazon software terms, whereby your rights to use the Amazon software will automatically terminate without notice from us. So you only have a mere right to use Amazon software. They can terminate it at any time at their sole discretion. And the fact is that if they sort of terminate your right to use the software, they are ultimately affecting your right of property over your device as a whole, because the device will become effectively unusable. Now, IoT companies exercise legal control over the device also through intellectual property. And this can be seen from many perspectives. Today, for reasons of time, I'm going to just mention one of them. There is a relatively recent case called Tom Cabinet. There is a case of the Court of Justice of the European Union that dealt with the legality of a virtual market for second-hand books. Now, the resale of IP protected products without the IP owner's permission is allowed by the principle of exhaustion. The principle of exhaustion is a very important principle in IP law, and essentially it means that once you put your product on the market, you cannot use your intellectual property rights to prevent the further distribution and resale of that product, or export of that product, or import of that product, etc., etc. You cannot control the product using your IP once you put it on the market, with minor exceptions. One of the rights that is exhausted is the right to distribution. So the right to sort of distribute copies of your copyright work. Conversely, under the InfoSoc directive, the right to communication to the public is not subject to exhaustion. So the question in this in Tom Cabinet was, is the supply by downloading for permanent use of an ebook covered by the concept of communication to the public that is not exhausted, or of distribution to the public that is exhausted? Now, this case really resembled a lot another famous case that is called Usesoft versus Oracle. In that case, it was a case about second-hand software, and the court decided that there was the right to distribution of a computer program was exhausted, regardless of whether the computer program was incorporated in a tangible medium. So once it's lawfully downloaded, you can resell your computer program. And this is a very important principle in terms of sort of freedom, free movement of goods and free competition. However, the Court of Justice in this more recent case, Tom Cabinet, really narrows down the scope of the Usesoft doctrine by arguing that the concept of computer program does not include ebooks, sorry, and therefore you cannot use Usesoft to sort of support the idea that that type of activity of resale of ebooks is legal, because the right to distribution is exhausted. And the Court of Justice also argued that the InfoSoc directive is predicated on the tangible-intangible divide. And intangible products that we can call digital copyright products, like ebooks, according to the court, are not distributed. They are communicated to the public. So since ebooks are not computer programs, they are digital copyright products, they don't fall under the Usesoft doctrine, and they are essentially not exhausted. Their right of communication to the public is not exhausted. Now, I know it all sounds pretty sort of technical, but I think it is quite an important example of how in recent times the Court of Justice has interpreted IP law in a very proprietary way. Because if you think about it, ebooks can easily fall within the definition of computer programs. I think it's very discretionary and sort of arbitrary, the decision of not considering ebooks as computer programs. And ultimately, this decision has the effect of what I call exhaustion of the principle of exhaustion. Essentially, you no longer, the principle of exhaustion doesn't really play a role in the context of the IoT. Now, IoT companies exercise legal control, factual control, but also technical control. And I think a very interesting example is the example of these American farmers who were using John Deere, which is a very expensive type of smart tractor. And at some point, the tractor broke, and they obviously wanted to fix it, but the company didn't allow them to. They said that this type of activity, the right to repair, essentially was a form of circumvention of their technological protection measures. So again, this is between copyright and technical forms of control. But I think it really gives you the idea of the problem. And interestingly, the farmers reacted by essentially downloading cracked Ukrainian software to repair their devices, their tractors. So the death of ownership has a threefold manifestation. You have decreased user power over the device, increased corporate power over the device in the form of post-sale control throughout the life cycle of the device, and increased corporate power over user-generated content. So what I wanted to explore, we don't have a lot of time remaining, but I'm going to try and be quick. I wanted to explore whether we could find a solution to the problem based on intellectual property exceptions. Now, I thought that there are a number of activities that are legal, even when when the IP owner doesn't allow these activities. And these are, and I think some of these IP exceptions are particularly relevant in the context of the IoT and the death of ownership. So regardless of whether the IoT company is trying to use their IP to stop you from doing certain things with your device, you can still do them basing yourself on intellectual property exceptions. For example, the exceptions under the software directive for study and test, the compilation under the InfoSoc directive for private copy of copyright works, but also the exceptions for insubstantial extraction and reutilization of databases, trade secret use for freedom of information purposes, use of trademark not in the course of trade and with due cause, and acts done privately and for non-commercial purposes in respect of objects covered by design rights. So you really, on the face of it, have a lot of sort of exceptions that you could rely on in order to sort of re-empower yourself as a user of a smart device. However, a strategy that is based on IP exceptions to counter the death of ownership is affected by two drawbacks. On the one hand, you have the problem that you cannot really use these exceptions against factual control, against control over service, against control over data power, and also against technological control that goes beyond digital rights management, essentially. But what I want to focus on today is another drawback that is the issue of IP overlaps. One of the reasons why why a strategy based on IP exceptions doesn't really work is because of IP overlaps. So let's see what's the reason of this phenomenon, and what is this phenomenon of IP overlaps. The reasons for this phenomenon are related to the fact that a really high number of intellectual property laws have been passed over time to increase the duration of intellectual property rights, the types of subject matter, the owner's exclusive rights, and they also introduced new IP rights. And this has been really pushed as an agenda, especially at the international level by the World Trade Organization and the World Intellectual Property Office. And I think we are seeing some of these sort of problems of excessive protection of intellectual property rights, even internationally during the pandemic. And to sort of give a sense of the problem with regards to smart objects, we can look at, for instance, the example of a smart device like the smartphone, where you have some aspects of it that are covered by trademarks, such as the ringtone, the way you swipe, obviously the logo, design rights for the shape, but the shape is also protected increasingly by copyright. We have a number of recent cases about shapes and copyright. But copyright will cover software, the sort of the code of the software, user manuals, ringtones, and to some extent interfaces, and trade secrets will cover the algorithms, and patents will cover the operating system, the user interface, data processing methods, etc., etc. So one simple object, 1,000 different intellectual property rights that partly overlap. The problem is that these IP overlaps risks essentially neutralizing the potential of IP exceptions, because many of the acts that are covered by IP rights exceptions constitute infringement of another IP right. So one thing that would be legal under one IP law becomes illegal under another IP law, and both apply to the same device. For example, I would just mention one example, reverse engineering. Reverse engineering is allowed under the software directive, but reverse engineering could constitute a form of patent infringement in the case of computer implemented inventions. And this has to be read jointly with the problem that IP exceptions are really very different one to the other. Some of them are mandatory, some of them are discretionary, some of them are binding, some of them can be overridden contractually, some of them cover commercial uses, some of them only private personal uses, some of them are regarded as user rights, some of them as mere defenses. So the end result is that when two sort of IP laws sort of overlap, the strictest regime will prevail on the less strict regime, with the end result that that when IP rights overlap, then there is really not much scope for relying on copyright exceptions to counter the death of ownership. So to conclude, I would like just to say that it can be said, and I think it is correct and fair to say that the IoT ushers in an era of ubiquitous computing and ubiquitous IP rights. And the more IP rights expand, the more user rights contract. If you're smart, if your device is smart, then chances are you don't really own it, either because you don't own it formally, or more likely because effectively you don't own it because the IoT company is retaining factual, legal, and technical control over the device. In theory, you could react to this type of situation by relying on IP exceptions, but in reality, you cannot really because of the phenomenon of IP overlaps. So which kind of other solutions we should explore? Antitrust, but we know that this is not a very good sort of solution, as proved by the European jurisprudence in the field of standard essential patenting, where essentially both European and national courts are interpreting antitrust law in a way that is really proprietary. Many solutions rely on ethics and ethical manifestos and ethical principles, etc. But this is a really tricky one because it's increasingly used ethics as simply an excuse not to regulate, or solutions by design. But like obviously data protection by design is just one example. Fair use, like copyright enforcement, automated copyright enforcement is another one. But we know that this form of techno-solutionism doesn't really work. The technology will not solve the problems of technology. So maybe more interesting things are things like open IoT. So efforts, bottom-up efforts to open the IoT and favor open data, open software, open hardware, etc., in order to have an IoT that really benefits society. And this is somehow related to the more general concept of commons that I think provides a very nice sort of very nice framing, theoretical and practical framing for new forms of collective resistance. And my feeling is that it's these types of collective forms of resistance that are really interesting, and they are the only ones that perhaps could re-empower consumers in the Internet of Things.